So there we go, the new rules on international families. I'll first give you just something broad on the regulation and the place of child abduction in the new regulation. Then I will say something brief about what I see as improvement, and then how this will work, what we think, and whether there is possibly still some room for improvement. So first, the place of child abduction in the regulation. It was already said yesterday that this regulation has become very long, very many pages, many articles and many recitals. But what was clear from the start at the negotiations of this regulation is that it's a continuation on the step of the Europeanization of international family law of the Brussels II bis regulation. So there was no stepping back, okay? The European Union has embarked on this road towards the abolition of exequatur and was not going to go back on it, okay? So while there might have been criticism on the abolition of exequatur, it was not an option to really go back on that. That's why the idea was to go towards more abolition of exequatur, but why we still have these two regimes that we spoke about already yesterday, but that are also relevant for child abduction, because we'll see that child abduction is kind of settled in both these two regimes of the privileged decisions on exequatur and the normal or ordinary provisions. And then, of course, this road of mutual trust, central authorities, direct communication between judges. We see more and more of that in the regulations. We will also have a session later in our series on specifically cooperation. Right. The regulation contains various references to the Hague Child Abduction Convention. In 24 of its recitals, it's already referring to this convention, much more than the previous one. And some of the recitals are an explanation of something that is in the provisions. Some of them are the kind of leftovers that didn't make it into the regulation itself. And I think Cristina González already said this yesterday, you know, the role of the recitals being a little bit unclear, because here we see that some of them are almost a repetition of what we see in the provision, saying a little bit more, but not that much more. And others really say things that are not in the regulation, because those were things that the Commission had initially proposed, but that did not make it through the negotiations. Those would be issues, for instance, the concentration of jurisdiction, where the Commission wanted to have a provision on that, but that provision was not retained through the negotiations. I think it's important here maybe also to remember that this is a regulation that had to be adopted through unanimity in the Council. It's family law, so we needed all member states to agree. And that made it difficult, I think, to be too ambitious. And that maybe explains also why so many issues were pushed into the recitals. There is a separate chapter on child abduction. This was already said yesterday that Article 11 of the current Brussels II bis regulation might not have been completely sufficient, in the sense of it's organizing so many things in one specific provision. Now we have this spread over various articles, starting from Article 22 through to Article 29, in a separate chapter. That's chapter 3. And before you think I can't count, you have articles 22 to 29 in that chapter, but then of course there are also specific provisions on child abduction in the part on recognition and enforcement, which is why I'm saying that adding all of them up, we get to 17 articles on child abduction and various other references as well. So what are the improvements? First of all, I think the approach can really be, we can really be happy about the improvements there. There is more explicit attention to children's rights. Article 21 contains a specific provision on hearing the child. That is a provision that we'll look at more, I think, this afternoon in the session chaired by Laura Carpaneto. This afternoon session will be more about children's rights and the place of children more generally. But what's interesting is Article 26 in our chapter on child abduction echoes Article 21, saying everything that we've said about hearing the child, that is as relevant for return proceedings in child abduction cases as it is in general. Then also explicit mention of children's rights in recitals 39 and 57. What I find personally really great is that the regulation refers explicitly to the UN Convention on the Rights of the Child. So not only to the EU Charter, which of course is EU law, but also to that international and global setting that we're all functioning in anyway. Of course, the Children's Rights Convention applies irrespective of whether Brussels IIter says so or not. But that reminder, I think, is quite significant. There is more attention to mediation, specifically on Article 25, which is also a good thing. One of the issues that was raised yesterday was, of course, the place of the voice of the child in these mediations. That is a difficult issue where the recitals are a little bit contradictory, even, I would say, saying that, yeah, we have to listen to the child, but sometimes, having agreement is also a good thing. And there, I think that we'll still need some more clarification. So I'm glad to hear that people are also working on the enforcement of mediation agreements and the place of the child in that agreement. Right. Another good improvement, I think, is the fact that agreements are facilitated. And this specifically, if you look at Article 10, sub 1, B2, this is new and quite significant. Article 10 is about the prorogation of jurisdiction. So parties choosing to submit their case to a particular court. And previously, this provision stated that you have to agree on jurisdiction before the institution of proceedings. So what happens if, there's a return proceeding, and in that return proceeding, the central authority manages to convince the parties to get to an agreement, or as happens in the Netherlands and Germany, you have specific institutions or organizations really encouraging parties to come to an agreement even after the proceedings have been instituted. Well, then, if they manage to get a sort of broad agreement, not only on the return of the child, but also on access, custody, contact, whatever, they can at that point actually elect to submit all of this to the court of the place where they are in the return proceedings. So I think that is an important improvement. Then the second set of improvements regard the timing. Central authorities have to acknowledge receipt of a return application within 5 days, and they have to act expeditiously after that. Every court gets 6 weeks to decide, and enforcement also has to take within 6 weeks, unless there are exceptional circumstances. The second chance procedure is still in there, but it is now embedded in the procedure on the substance. That should be Article 29. I see that the 29 has fallen off the slide there, I'm sorry. And recitals 51 and 52. I think Katarina Trimmings will say more about the second chance procedure, so I'm going to skip to the next slide, which is really my question about how is this going to work in practice? How is this hearing of the child going to work? We know that there are different standards in the different member states, and particularly in child abduction, the issue of manipulation comes up. How is this going to work in practice? Let's see. I think Camilla is also going to come back on this in her presentation. Will the speed, the 6 weeks periods really work? Because the Hague Convention in 1980 already stated this, saying that return proceedings should take 6 weeks. And what we've seen over the years is an increase in the time that it's taking. What we've also seen is that introducing EU legislation does sometimes help as a kind of, just getting everybody on the same page and reminding them of the importance of this, and kind of an awareness raising, which gets me to the next point of the positive influence sometimes of member states' legislation on each other. For instance, we don't have concentration in all countries, we have them in some, and the recital refers to this idea of concentration, but the fact that countries are aware of each other's legislation might have a positive effect. How will mediation work? Will there be legal aid always granted for mediation? Will there be enough money for proper structures for mediation to really get that off the ground? I hope so. An issue for the proper functioning of the regulation, I think, is the very complex enforcement rules. We have referred to this yesterday, and I think one of the points that I just wanted to highlight today is the point made by Mirjam de Hemptine, who couldn't join us yesterday, who could join us yesterday, but not today, sorry, about Article 50, right? So you have the enforcement, but you have the abolition of exequatur, but there is also this idea of, but if a later court rules differently. So you have all these complex rules, and we will have to see how they function in practice. Is there still room for improvement? Yes, of course. The second chance procedure or the override mechanism. One of the issues there that some of us really argued for is, if you're going to keep this mechanism, then it should function only in the application of the grave risk exception. Let me explain what I mean. Let's say the child is abducted from Belgium to Poland, and the Polish court refuses the return based on the grave risk. All right, then you have the second chance procedure within the custody proceedings in Belgium, which is the habitual residence of the child. However, if the child in Poland says, oh no, I don't want to go back, then this entire override mechanism kicks in as well. So what some of us were saying is, well, don't introduce this mechanism when the refusal is based on the child's own objection to return, but it's still there. That's in Article 29. And then some of the issues that were difficult to improve because they're just not inside the EU's competence. As I've already said, the duty to concentrate jurisdiction. The Commission proposed this, but some of the member states said, no, we don't want this in the regulation, because this would mean that the EU is interfering in the way in which we organize our own judiciary. And this is not something we want interference into. So now it's just become a recommendation almost in the recital. The funding of mediation and central authorities, which is also in the recital. Of course, the European Union cannot tell states you have to give so much money because that's their own budgets. But it's good, I think, that at least there's the recommendation that these central authorities must be sufficiently funded. There was also an idea raised that there should be only one appeal to a return procedure, but also this would be an interference in the organization of the judiciary and civil procedure in general. So that was pushed into a recital. Central authorities, quite interestingly, this was also something that somebody raised yesterday. Recital 73 states that central authorities, the functions of central authorities under the regulation do not apply when we're applying the Hague Convention of 1980. But then if you look at, for instance, Article 27 and recitals 45 and 46, which are specifically about child abduction and assessing whether there's a grave risk in the other country, assessing whether the grave risk can be addressed in the country of the habitual residence, then there's a reference to the central authorities. So it's a bit strange that, to me, it seems like there's a contradiction between recitals 73 and then Article 27 and recitals 45 and 46. And then something that I think still needs improvement is also something Cristina González Beilfuss referred to yesterday, which is lawful or court-approved relocation. She said that we should be rewiring how we think about this. In other words, making sure that parents, very often mothers, have the opportunity to actually apply to a court and to consider the entire family situation beforehand and make a proper arrangement, rather than feeling, okay, well, the law is not on my side, I'm going to take my child and run. So that, I think, would be good if anything could be done on that score.